Good morning, everybody. Welcome to this commercial property webinar, June 2025 from Kuits Solicitors. My name's Adam Himes. I'm a partner in the commercial property department, and I'll be joined by some of my colleagues in some talks that hopefully you'll find interesting. So I'll be joined by Christian Eagle, partner in property litigation, David Moroney, partner in commercial property, and Rebecca Lowe, partner in our licensing department. So I'll kick off today's webinar with a talk which is somewhat light in nature. I'll be talking about rectification and the register, and can the Land Registry ever be wrong? So this is a case that I'll be talking about. It's between two parties, Suhitharan and Ivaskevich. For ease of pronunciation, I'm going to just call them Mr. S and Mr. I for the purposes of this talk. It's a case regarding residential property, but it is relevant to all land, including commercial property. And it turns on whether the applicant can prove to the Land Registry that there was a mistake on the register. And it's to do with the burden and the standard of proof related to that mistake. So the facts, as I say, it's residential property, but it's equally applicable to commercial property. You've got two titles here to land. You've got number 4, Beancroft Road, Bedford, owned by Mr. I. You'll see at the top there. And at the bottom, number 2, Beancroft Road, Bedford, owned by Mr. S. The disputed land, you should just see shaded grey on the plan at the bottom at 2 Beancroft Road, comprised a garage with a driveway for parking a car in front. There was a side door off the garage into the land at number 4, and that's comprised the disputed land in total. The grey disputed land was registered to Mr. S at number 2 Beancroft Road, but Mr. I claimed that it had been registered by mistake and sought rectification of the title to claim the land back, as it were. So Mr. I bought number 4 in 2000, in the year 2000. He believed that the disputed land had been included in that purchase. The estate agent's brochure seemed to confirm this. Accordingly, Mr. I parked a car on the driveway and used the garage for storage for approximately 19 years. So considerable period of time of use, which you should bear in mind in this case. In 2019, Mr. S purchased the neighbouring property at number 2, which included on the title the grey disputed land. He objected to Mr. I's use. He erected a bollard on the driveway to prevent access to it. And unsurprisingly, Mr. I applied to the Land Registry in respect of this situation. So in applying to the Land Registry and claiming rectification of a mistake, Mr. I did not produce any deed that transferred title to the disputed land to number 4 Beancroft, his property, nor did he produce his solicitor's conveyancing file from 2000. His argument was basically based on pre-registration deeds, which showed that the disputed land was, at some time in the past, part of number 4. And therefore, he argued there must have been a mistake on first registration. Now, he offered no information as to when first registration took place. He just referred to, as I say, a number of pre-registration deeds, which indicated that, in his view, there was a mistake. Now, the law with regard to rectifying the mistake in the Land Registry Register is set out in Schedule 6 to the Land Registration Act. So I'll very briefly go over what that states and provides for. It makes provision for the alteration of the register, including rectification, which involves the correction of a mistake and which prejudicially affects the title of a registered proprietor. That is rectification. And the registrar may alter the register for the purpose of correcting a mistake. Now, no alteration affecting the title of the proprietor of an estate and land may be made without consent unless the person affected has, by fraud or lack of proper care, caused or substantially contributed to the mistake, or that it would for any other reason be unjust for the alteration not to be made. So essentially there is a test. The Land Registry can't just go ahead and correct the register against the interests of any party. Now, if the registrar does have the power to make the alteration, it must be made unless there are exceptional circumstances applying. Now, in this case, there was no dispute that Mr. I was seeking rectification, so the Act would apply. Taking the land away from 2 and adding it to number 4 would prejudicially affect Mr. S. So Mr. I had to show on the balance of probabilities that including the disputed land in the title to number 2 and excluding from number 4 was a mistake. If he succeeded, then that would be rectified, but the first tier tribunal, that's the FTT, would have to consider fraud, unjust or exceptional circumstances, as I've mentioned. Now, in the first instance, he won. The judge said, I am just persuaded that on the balance of probabilities, the disputed land was included in number 2's title by mistake. Now, Mr. I's evidence, as I've said, was just a number of old deeds, conveyances from 1903, 1944, 1946. For example, showed that the frontage of number 4 was sufficiently wide that it did include the garage and the driveway. So it was historic evidence, really. And then there was therefore evidence that in the past, the disputed land was part of number 4. Equally, there was evidence that it wasn't included in number 2 in terms of an earlier conveyance from 1929 and other evidence that I refer to there. The judge said it was not possible to say how the mistake was made, but these are questions, not questions that I have to answer. The judge said that there's nothing that remotely suggests that a transfer of the disputed land to number 2 took place, and the applicant's evidence is to the contrary. So basically, the judge agreed, on balance, there must have been a mistake. Simple as that. However, the appeal on which Mr. I lost turned on 2 things. Proof of mistake requires both land added to one title erroneously and land taken from another title erroneously. There were 2 aspects there. And the appeal found that the first tribunal was wrong to find a mistake on the register. 2 mistakes were needed, neither of which had been shown by Mr. I. He'd failed to show the nature of the mistakes. And in dismissing the possibility that there could have been a sale of the land to number 2, the judge had effectively reversed the burden of proof, which was inequitable. And the appeal court felt that the judge's finding that there was a mistake without any finding as to what happened and when was unacceptable. And on the evidence before him, there was no basis to find that 2 mistakes had happened on the balance of probabilities. So they overturned it. So the conclusion from this case, as I say, it's very specific. It turns on its facts, but it's quite interesting and useful in terms of where people can go wrong with the register and the land registry. So there was no mistake to be rectified. Mr. I hadn't proved that the land was both omitted from number 4 and included in number 2 by mistake. There was not enough information about the titles. He did not look at historic copies of the register, which were available. He did not find out when first registration of the 2 properties took place, etc. And all that he proved was that the register in 2019 was inconsistent with an earlier title in 1946. So, points to note. I think this comment from the case on appeal is interesting. Title to registered land depends on registration and not deeds. And the fact that the registered title is inconsistent with pre-registration deeds some decades old is not by itself evidence that there is a mistake on the register. So in summary, it's easy to jump to conclusions about title, looking at old title deeds and assuming they're definitive, sort of not looking and seeing the wood for the trees, as it were, and the important need to collect all relevant facts and information and be properly advised in these sort of cases, I think are the takeaway points from that. So that concludes my talk, and I'm now going to hand over to my colleague, Chris, who's going to be talking about recovering commercial rent arrears and a practical guide for landlords.
Thank you, Adam. Yes, good morning, and thank you for attending today. My name is Chris Eagle, and I'm a partner in the property litigation team at Kuits. As Adam said, I have the task of speaking to you today about the options for rent arrears recovery in commercial leases. Rent arrears are unfortunately not exciting, but they're an all too common issue for commercial landlords, and it's essential to approach recovery with a clear understanding of the options available for each situation. Not only from a legal standpoint, but also from a commercial one. Landlords need to ensure that they take the right approach for each particular circumstance. There is not an ideal solution applicable to all circumstances, so you must tailor your options to your specific case. Now, today I'm going to outline 3 key routes available to you as commercial landlords. Forfeiture by peaceable re-entry, commercial rent arrears recovery, for which we use the awkward acronym CRA, and issuing proceedings to seek a judgment for arrears. I'm also going to highlight the potential pitfalls with each option and suggest when one option might be more appropriate or attractive than another. It is important to bear in mind that in electing to pursue a particular course can have ramifications on the availability of pursuing other options of enforcement. For example, if a landlord exercises a CRA recovery or pursues a money judgment via the county court, they can't then forfeit a lease for the same arrears. As a result, I'd always recommend taking legal advice at the earliest opportunity so we can give strategic advice in line with your commercial goals. Now, I'm initially going to speak to you about forfeiture by peaceable re-entry. That's the landlord's right to terminate a lease when a tenant breaches its terms, most commonly for non-payment of rent. Just find the right slide. Peaceable re-entry is a method of forfeiture that does not require a court order. Instead, it involves physically re-entering the premises, typically by changing the locks while the tenant is absent. This act must be unambiguous and is often carried out with a certified bailiff or enforcement agent present to avoid accusations of unlawful eviction. As you can imagine, this is also usually carried out outside of business hours and most often in the very early hours when there is no one in the premises. Obviously, it would be unlawful to change the locks of premises when it's occupied. To be clear, forfeiture can only be done when the lease expressly provides for it, and rent must be at least 7 days overdue, unless the lease states otherwise. Most commonly, we see leases providing for 21 days before such action can be taken. But here is a key warning. Once a lease is forfeit, it's fully determined. And by that, I mean it's at an end. You as the landlord become liable for business rates on the property, and sometimes from the next day or a short time thereafter. If the property remains vacant for any time, especially if it's hard to re-let, this can become a serious financial benefit with both the insurance obligations on top of the business rates. As such, the market conditions and the condition of the property need to be considered. Nevertheless, there are good reasons to end a tenancy, as you can imagine. Also, be aware that tenants can apply for relief from forfeiture, particularly if they pay the arrears promptly after re-entry. This can lead to litigation and uncertainty. And if the remedy is applied for promptly with the full arrears paid, the remedy for non-payment breach, then there is often an agreement reached to let the tenant back into the property to avoid prolonged court action and costs. Now, a commonly asked question is whether a landlord can sell a tenant's goods or property once they forfeit a lease. This is the reason I've chose to do this talk today, because every time we seek to forfeit a lease, somebody says, can I sell the tenant's stock? As with all things legal related, the answer is not black and white, and it depends. Legal advice is essential in these circumstances. Once a landlord has forfeit, any items in the premises remain the tenant's. They must be given an opportunity to collect the same. After a period of time, if the tenant has not collected the goods, then the landlord can dispose of the items or sell them. However, the landlord is obligated to account to the tenant for what happened to those items. If they're sold, cost of sale can be deducted and the rent arrears can be deducted before any surplus, if any, is passed to the tenant. We do see situations where people forfeit improperly without advice, and they end up facing claims for tenant chattels because they've not dealt with them properly. Now going to move on to commercial rent arrears recovery, or CRAR. This is the second option, and it replaced the old remedy of distress or distraining us to rent, and it's been around in this form for just over 10 years. It allows landlords of commercial premises to instruct certified enforcement agents to take control of goods or stock and ultimately sell them to recover rent. But CRAR comes with conditions. It applies only to principal rent. It doesn't apply to service charges, insurance, or other sums that may be due. At least 7 days' rent must be overdue before you can serve notice. You must then serve minimum 7-day enforcement notice, giving the tenant time to pay. That's before the goods are taken. It cannot be used if any part of the premises are residential, even if that use is unauthorised. So CRAR is more transparent and regulated than the old distress system, which reduces the risk of abuse, but it's also less flexible. Practically, unless the tenant has available assets on site, CRAR may have little effect. Tenants who suspect enforcement is coming may recover or conceal goods or simply have very little to seize. But it is an important weapon in your armoury. And of course, the enforcement agents can take payment on the day to avoid any embarrassment. My advice at the outset would always be to take advice before pursuing this option. There are other considerations that I've had to advise landlords in relation to goods that were held in a truck while not being in the premises, and similarly goods in container units outside the premises. Now, the next option available that I'm going to talk about now is issuing proceedings for judgment. This is often the best route when the tenant remains in occupation. You don't want to terminate the lease, and this can place a burden on the landlord, as I said earlier, and there are ongoing prospects of recovery or assets outside of the premises. Once judgment is obtained, you can enforce it in a variety of ways, including charging orders, third-party debt orders, or attachment of earnings if a personal guarantor is involved. Importantly, this option preserves the lease and your rental income stream. That can be critical. Forfeiture is final. Once you've re-entered, you cannot later change your mind. With judgment, however, you retain flexibility. If the tenant recovers financially, you can continue to receive rent and maintain the relationship. Remember, a lease is a good investment representing future income, and that is the reason I advise that you consider your options carefully, particularly with forfeiture ending the lease. There are drawbacks, of course, to seeking judgment. Litigation takes time, costs money, and even with a judgment, enforcement isn't easy, particularly if the tenant is insolvent or asset poor. You also need to factor in legal fees, which may or may not be recoverable. My advice at the outset will be to get a guarantee. If you have a guarantee, use it to force the issue and pursue the guarantors. They will not want a judgment or statutory demand. So which route do you choose? This depends on your commercial priorities. You need to ask yourself, do I want to end the lease and regain control of the property? Or do I want to preserve the relationship and keep the rental stream flowing? If you're dealing with a failing business and is in a weak market, forfeiture might help you cut your losses, but don't underestimate the cost of business rates and void periods. If the tenant is asset rich or simply struggling temporarily, seeking judgment might be more commercially sensible. CRAR sits in the middle. It's quick, regulated, non-litigious, but only effective where tenants have goods of value on site or in reality offer up payment immediately to avoid the enforcement or embarrassment. Please also consider timing. If you're closer to a quarter day or a rent review, triggering forfeiture will prejudice negotiations or complicate future recovery. So, what are my concluding thoughts? Rent recovery is a legal decision, but it's also a commercial one. Each remedy has its pros and cons. Establish what you want to achieve. Forfeiture is final. You need to approach that remedy with caution, particularly if you want to determine the lease. You need to understand the tools in your kit and don't always use a sledgehammer. Judgment preserves your position and allows the lease to continue, and CRA is a very useful remedy, but I would only advise really using it in limited circumstances. Essentially, I would always take advice before acting, particularly with forfeiture that can have permanent consequences. Thank you for attending today, and if you need any clarity or have any questions, please don't hesitate to get in touch. I'm now going to hand over to my colleague, David Moroney, who's going to talk about some important developments.
Thanks, Christian. Good morning, everybody. My name is David Moroney. I'm a partner in the Commercial Property Department here at Kuits. This morning, I'll be very briefly considering three newish matters, one being a regulatory change, one an analysis, and one a piece of case law. These are specifically the new AML regulations for letting agents and also landlords, movement in the Manchester office market over the past 12 to 18 months, and the recent 2025 case of London Trocadero 2015 LLP versus Picturehouse Cinemas Ltd, Gallery Cinemas Ltd, and Cineworld Cinemas Ltd, which I think we'll just refer to as Trocadero going forward. So kicking off with, as you can see on screen, the new AML regulations for letting agents. As of 14 May, new regulations have been introduced, which have significantly expanded anti-money laundering compliance obligations for letting agents, and furthermore have now added landlords into these obligations. The key changes are AML compliance is now required for all rental properties, not simply those with monthly rents exceeding €10,000. And as mentioned, responsibility has been broadened to private landlords as well as letting agents. So what does AML compliance necessitate? Firstly, it would be expected that a letting agent and or landlord would verify the identity of adult tenants, and to the extent you're a letting agent, also landlords, by collecting official photo ID and proof of address. It would also be necessary to check names on UK sanctions list, and also to keep records of all of these checks for a period of at least 5 years after the relevant tenancy ends. And just be mindful that there might be GDPR consequences of doing that, which we can assist you with if you need any further advice. Landlords and letting agents would also need to be mindful and, if necessary, report suspicious transactions and keep up-to-date AML regulations internally, which can include giving regular training to employees. In addition, if appropriate, it may also be advisable to consider personal ID checks, signature comparisons, and the use of digital verification tools. Now, what can you look out for? And most of these seem very obvious, but it's worth mentioning them. You'd obviously be alerted by a refusal to provide documents or evidence of ID, documentation which is inconsistent or appears to have been altered, people wanting to pay large sums in cash, which should always be a red flag in most circumstances, and landlord requesting that sums are paid to a third party. Now, with the new obligations, there comes new consequences of non-compliance. These now can encompass substantial fines, business restrictions, or even potentially imprisonment for a period of up to 7 years. So, as you'll note, essentially the scope of these regulations have been significantly expanded, as have the penalties for non-compliance. And both landlords and letting agents should now ensure that they are fully briefed as to the obligations they have to satisfy and ensure they're taking appropriate steps to implement these new regulations. So moving on to point 2, the Manchester office market. This is a very brief analysis over the past 2024 and early 2025. I think, as most people were aware, there was a fear that COVID and its aftermath could very well signal the end of the office market. However, as far as Manchester is concerned, and to paraphrase Mark Twain, the reports of its death appear to have been greatly exaggerated. In the post-pandemic market, Manchester is actually now seeing a shift back towards office working, albeit in a hybrid manner, and with an increasing focus on prime office space. To put some numbers around this, in 2024, 70% of office relocations above 10,000 square feet actually saw occupiers increasing rather than decreasing their size of their workspace. This was driven largely by a need and desire for greater amenity space and larger businesses mandating a return to the office. To give that some further context, that was up from 30% in 2023, so quite a significant jump. Office take-up in 2024 in Manchester was also significant, reaching 1.22 million square feet, which reflected an increase of 29% on 2023, and also sits 17% higher than the 5-year annual average. The trend continued into 2025 during Q1, which saw 320,000 square feet of space being taken, which was 22% above the 5-year quarterly average. And notably, prime and grade A space accounts for approximately 50% of this total activity. Needless to say, rents have actually followed the demand, with a steady rise edging ever closer towards £50 per square foot for prime city centre office space. Savills are currently placing prime headline rent in Manchester at £45 per square foot, and forecasts that the £50 per square foot mark will be achieved by 2026, so not too far away. So is this necessarily good news for everybody who owns office stock in Manchester? Not necessarily. As mentioned, the drive is largely now towards the occupation of prime space, so there's an inexhaustible supply of this, which drives rental values for those holding space of this nature, but doesn't necessarily benefit others. Given the limited supply of this nature, there is, of course, an increasingly limited supply of space of this nature entering the market. So the anticipation is that we will see a greater focus on refurbishment of existing stock together with the creation of new to create prime space over the coming 12 to 24 months. However, overall, to summarise, it appears that contrary to concerns, the office market in Manchester is actually going from strength to strength. So finally, moving on to the London Trocadero case. This was a case which related to a dispute regarding the liability for rent arrears during COVID-19. Whilst the landlord was successful in relation to the arrears, a counterclaim evolved in relation to the payment of insurance rent. The brief facts are that London Trocadero's landlord was, as is common, obliged to insure the property and recover the expenses by charging other tenants an insurance rent. The insurance was arranged through a standard practice plot policy that encapsulated a large portfolio of properties. The aggregate premium was paid to Criterion Group, who delegated the task of arranging insurance to a subsidiary company, Criterion Capital Limited, who were actually a group company of the landlord. Once an apportionment had been made to a particular property, an additional apportionment was obviously necessary to allocate the premium to the various units. Picturehouse had been paying the insurance rent, but disputed the sum paid on the basis that undisclosed fees disproportionately inflated this sum. The case actually raised 3 separate issues. 2 were relatively specific to the property and related to the maintenance of sprinklers and a high insurance excess. However, 1 has wider implications for landlords and related to the commission claimed by landlords for placing insurance policies. Key points of this case are that for the period 2015-16 to 2021-22, large parts of the insurance rent paid by the tenant had in fact been paid back to the landlord's group as landlord's commission for placing the policy, which can be relatively common. The figures in the judgment actually set out that in some years the commission for the cinema as a percentage of gross premium excluding IPT, actually exceeded 50%. It was a significant sum. For the period 22 to 23, instead of the above, the landlord actually charged the tenant what they referred to as a placement, administration and work transfer fee at a rate of 35% of the applicable insurance premium. The matter was decided in favour of the tenant. The court actually found on 3 bases, essentially. Firstly, the sums were not an amount payable by way of premium for keeping the centre insured, that being a reference to the drafting within the lease. Consequently, the sums collected in relation to the same had to be repaid to the tenant. As mentioned, that was largely based upon the drafting of the insurance provisions within the lease and could turn on the drafting. It does, however, reflect, in my view, the court adopting a position which is perceived by the court to be equitable, which is likely to be replicated in the future absent clear drafting to the contrary, that being that the landlord should not be unjustly enriched by the retention of commission payments. And that's moving on to the second point, sort of expanded on that. The judge decided that there was an implied term within a lease which requires the landlord to act reasonably when arranging insurance, and that the landlord must do so on arm's length terms, and finally, as mentioned, must not be unduly enriched off the back of the tenant. And finally, although the court recognised that commission rebates are common within the market, it concluded that standard lease terms do not entitle the landlord to benefit at the tenant's expense in relation to these, unless there is explicit agreement with the tenant or explicit clauses within the lease to the contrary. Now, the third element there, I think from a landlord's perspective, potentially offers a glimmer of hope, because this may be a path that typical landlords wish to pursue. However, it needs to be borne in mind that even if a landlord seeks to draft around this issue, any clause which entitles the landlord to recover and retain commission must firstly be clear and unambiguous, and it must be clear the tenant has agreed to the same, and further that unreasonable percentages, and the example given was 60%, but I suspect it would be found to be much lower than that in practice, will be overruled by courts, even if expressly stated within the lease, and even if the tenants actually agreed to the specific percentage at the time the lease was entered into. As you'll appreciate, this is a very tenant-friendly finding, and the practical implications for landlords are that the retention of commissions may become hugely problematic in the future and even over the previous few years. It's quite possible now that this will alert tenants to the possibility that landlords are potentially retaining insurance commission without disclosing the same, which could result in tenants seeking to analyse insurance rent, and more worryingly for landlords seeking to claim effectively rebates of payments historically made. And that concludes my hopefully brief summary of those points. So if I can now hand over to my partner, Rebecca Lowe, who will be considering, as you see, the Terrorism Protection of Premises Act.
Yeah, morning all. Thanks, David. As David says, my name is Rebecca Lowe. I'm a partner in the licensing team here at Kuits. We act for hospitality operators, events organisers, but also developers and property owners with a leisure portfolio across the country. As you've heard, I'm here to discuss the Terrorism Protection of Premises Act 2025, which received royal assent on the 3rd of April this year. I will be discussing what the law does, what premises it applies to, who is responsible for compliance with it and what those people must do, and finally, who will oversee compliance with the law and enforce the legislation. So first of all, the legislation is also known as Martyn's Law. In memory of Martyn Het, one of the victims of the Manchester Arena attack in 2017. The legislation has been the result of many years of campaigning by Martyn's mother, Fegan Murray. It was Fegan's view that the attack at the arena exposed some fairly substantial gaps in security measures at public events and public venues. So the legislation has the aim of improving public safety at such locations by requiring enhanced preparedness for a potential terrorist attack. So Martyn's Law will require certain practical steps to be taken to reduce the risk of harm from a terrorist attack. As I said, the legislation came into force this year, fairly recently, but it has at least, or it will have at least a 2-year implementation period. So we're likely to see the requirements of this legislation bite in April 2027, or potentially even afterwards. Legislative guidance on this will be published in due course, and that will help those who will be subject to this legislation in their preparedness for its implementation. However, what we would say is that a wide variety of businesses, entities and individuals, including property owners, will need to start thinking now about their preparedness, because as we'll see, the legislation is fairly wide-ranging in its application. And we can see the wide-ranging nature of it in terms of what the legislation calls qualifying premises. So those are premises to which the legislation will apply. There are two types of qualifying premises, and they're called either standard or enhanced tier, as well as qualifying events, which I'll touch on briefly. So we can see here what I was talking about in terms of the fairly wide-ranging nature of this legislation, an incredibly wide definition here in terms of what a standard tier premises is. So a qualifying premises under the standard tier is quite simply a building or part of a building. There are then other requirements which would need to be satisfied in order for that building to fall under the remit of Martyn's Law. So firstly, the premises must be wholly or mainly used for retail, leisure, entertainment, or hospitality purposes. It must then also be reasonable to expect that between 200 people and 799 people might be present on site at any one time. So that's not all the time by any means, but a building with that sort of capacity would fall under the remit of this legislation. Finally, the premises need not be excluded under the Act, and there are certain specific exclusions provided in the legislation, such as parliamentary buildings, for example. But essentially, the message here is that to be subject to the standard tier requirements under Martyn's Law, essentially all that needs to be in place is that there is a building which is wholly or mainly used for retail or leisure purposes, and it's got a capacity of at least 200 people. The enhanced tier, then, in terms of Martyn's Law, is exactly the same in terms of definition. So a building, again, wholly or mainly used for retail, hospitality, leisure, but larger capacity here. So it's reasonable to expect that at least 800 people would be present at the premises at any one time. And again, as long as it's not excluded, that would be captured by the legislation. So any property owner or developer with a fairly reasonable sized retail or leisure unit as part of their portfolio should have an interest in this legislation. As well as qualifying premises, as I said, the Act does also provide for qualifying events. I'm just going to touch on these really briefly because really they're more relevant to events organisers than property owners, but they are worth knowing about for owners of say, open spaces or areas used for events. So in those circumstances that you can see on the slide here, a qualifying event would also fall into the remit of Martyn's Law. So if a premises is a qualifying premises or an event is a qualifying event, there are certain requirements that must be adhered to. And the people responsible for that adherence are, for qualifying premises, a person who has control of the premises when it is used for its main activity. So when it is used for retail, hospitality or leisure. So this is usually someone who's sort of responsible for the day-to-day running of the premises. So it isn't necessarily therefore the legal owner of the premises, but equally it could be depending on circumstances. For qualifying events, it's the person who has control of the premises at the time that the event's being carried out and who has control of how the event is managed, who would be considered to be the responsible person. So control is therefore key to determining who the responsible person is, and this would need to be considered on a case-by-case basis. I'll say a little more about that in terms of the guidance that we're expecting to accompany this legislation shortly. So in terms of the responsible person, the legislation will then require them to do certain things in respect of any qualifying premises or indeed qualifying events. So for a standard tier premises, so remember these are premises with a capacity that sits between 200 and 799 people at any one time. If you're a responsible person for a standard tier premises, you would firstly be required to notify the SIA, that's the Security Industry Authority, of the premises. And then, so far as is reasonably practical, you must have appropriate public protection procedures in place. So these are procedures that would be followed by people working at the premises if an act of terrorism were to occur. These procedures would be expected to reduce the risk of harm being caused by a terror attack. So we're talking about things like procedures for evacuation, procedures for evacuation, so movement of people to a safe space if a terror attack's taking place, locking down of the premises, and then communicating with individuals on the premises if an emergency situation were to take place. So essentially the aim for standard tier premises here is to improve staff preparedness for a terror attack attack taking place and their response to that, if the worst were to happen. Responsible persons for enhanced tier premises and also for those qualifying events, if relevant, are similar, again, required to notify the SIA of the premises and implement public protection procedures. However, the two differences here are, firstly, that the appropriate procedures not only need to deal with the response and the reduction of risk of physical harm if a terror attack were to occur, but also look at reducing the vulnerability of the premises to a terror attack in the first place. So, for example, there might need to be provision of monitoring the exterior of the premises or its immediate vicinity in terms of being aware of what might be targeted at the premises. Enhanced tier premises are also required to document their procedures and share them with the SIA, who will be the regulator. So there's no specific requirement for documentation for a standard tier premises, but an enhanced tier premises does have that requirement. And they also, any enhanced tier premises would need to designate a senior individual to be responsible for compliance with this. So essentially, therefore, what we're looking at here is the legislation requiring the risk assessment of a terror threat and then the consideration of procedures required to reduce the harm that might occur if a terrorist attack did in fact happen. In terms of enforcement then, the SIA, who I've mentioned, so that's the Security Industry Authority, will be in charge of the regulation and enforcement of these requirements. The SIA are an existing body. They regulate security staff, so door staff that you would see on nightclubs or bars are regulated currently by the SIA. But this area is an entirely new remit for them. And so that is part of the reason for the 2-year implementation period that we're seeing in respect of this legislation. That's to allow time for this new role to be developed and prepared for by the SIA. The SIA will advise responsible people on how to comply with the requirements of Martyn's Law, but it'll also have powers to access premises, conduct inspections, and assess compliance with the law. Where there are instances of non-compliance, the SIA will be able to issue a range of civil sanctions, including compliance notices, restriction notices, penalty notices, and in certain instances, non-compliance will be deemed a criminal offence, and the fines that can be issued in respect of any breach of Martyn's Law are really quite substantial. So this is something that people do need to be aware of and prepared for. As I've said, government guidance on this is to follow, so more detail will be available to potential responsible persons in due course to allow them to navigate the practicalities of meeting these requirements. The guidance will include, we hope, information on assessing terror-related risks, assistance in developing response procedures, how qualifying premises and responsible persons would meet any training or documentation requirements. And hopefully also it will provide some practical examples of who a responsible person would be in any given circumstance. The reference, obviously, in the legislation is to somebody who has control over premises, but actually, from our point of view, the concern is that there are various different entities who might be seen to have control over a premises, particularly, if you're thinking something like, say, a fairly large shopping centre. If we can assist your business with preparedness for this legislation, contact details are on screen. Thanks for attending this morning, and I'll hand back to Adam to conclude.
Yes, thanks very much, Rebecca, and thanks to everybody for joining and listening to our webinar. I hope you've found it interesting and useful. I certainly learned a few things there from my partners and colleagues. So a transcript or a copy of the whole webinar will be made available, we believe. We'll share that with you, and it should be available on a YouTube stream as well. So it just leaves for me to thank you again, and hope you'll join us on our next webinar for property. And just to remind everybody that we do have the full range of commercial services that we've been speaking about on this webinar, be it commercial property, residential, litigation, licensing, or any of your commercial legal needs. We'd be happy to assist you where appropriate. So thank you again.